You by the personal injury attorneys of Perinick, Caulfield, Haverhill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. This is Attorney Matthew Noyes, and I am one of the partners at Perinick, Caulfield, Haverhill, and Noyes, here for another hour to be available to answer any questions you have regarding any type of law, really. We specialize in personal injury, workers' compensation, Social Security disability, slip and falls, medical malpractice, and any cases that really deal with insurance companies. But myself and my partner here we're here to answer any questions that we have. And so without further ado, let me introduce our co-host, my partner, Brian Caulfield. Brian, thank you again for showing up.
Thanks, Matt. Looking forward to talking to everybody about the law.
Yes, and so before we get into the first part, let's give the numbers out. The number to call is 727-441-3000. And now I just did hit click live. So now we are live on Facebook, and that's on our firm's Facebook page, and that's at Perinick, Caulfield, Haverhill, and Noyes Injury Lawyers, and we're live on Facebook right now. So if you don't want to call in with a question, but you still have a question, just send a comment on Facebook, and I'd be happy to address those right away.
And for those of you who don't have Facebook, the show is also available on the stations, on the law firm's YouTube channel as well.
That's exactly right. That's Matt, our show director there. And we are also live on the firm's YouTube. So please feel free to watch us, listen to us, and we're here to answer any questions that you have regarding the law. This is FLA Law on the radio. And my partner, Brian Caulfield, can tell us all about FLA Law and also, before we started talking about the firm and the TV show, why don't you reintroduce yourself to our listeners? Tell them a little bit about yourself, Brian.
All right. Well, as you know, Matt, I am a proud local graduate of law school. I went to Stetson University College of Law, graduated there in 1988. Actually started working at our firm when I was a law clerk, a second-year law student. Way back in 1987. So I've been a lawyer at the firm for about 35 years, and I practice personal injury, wrongful death, and medical malpractice law, and I am a board-certified civil trial lawyer. So any questions that anyone has about personal injury or any laws that pertain to personal injury, as well as some major new law changes, what happens to people that have been injured in a car accident, what kind of auto insurance people should buy, all those types of questions are the kinds of questions that we can certainly tackle this evening.
Sure. And again, if you have any questions regarding that, it's 727-441-3000. Brian, you've been with Perinick, Caulfield, Haverhill, and Noyes for a long time. Why don't you kind of give the history of our firm, and FLA Law and why we call this show FLA Law on the radio?
Sure. Our firm was actually founded in 1955. You won't find too many law firms around that have that type of a history.
I think we're the oldest in Tampa Bay.
Yeah, we are the oldest firm in Tampa Bay. Our firm practices exclusively in the area of personal injury and related law, like Social Security, total disability, personal injury, wrongful death, medical malpractice. We have done FLA Law both as a radio show, and as you know, Matt, years ago, we also had FLA Law as a television show. Before Bay News 9 took over Channel 9, we actually had a long-running live call-in talk show known as FLA Law. So this is kind of the revival of that.
That's right. And the TV show was 4 days a week, I think, right? Monday, Tuesday in Pinellas, and 2 other days up in Pasco County.
Yes. Early in my career, I did an awful lot of driving to the studios, and it was usually a pretty late start, a 7 or 8 p.m. start.
Right. We were prime time.
We were prime time.
And that Pasco County, when we used to drive there, remember, it was just all full of fields and everything. Now it's all developed down that way and such.
That's really kind of the story of West Central Florida, isn't it? The growth here has just been been unbelievable. And of course, you can kind of see, that when you're on the roads, the travel times have become incredible. And, it's been so long, and you see the changes that have taken place, not only to our community, but what have kind of changes have taken place culturally.
Right.
Everybody is on their cellular telephone when they're driving. Just coming here, I was on a 2-lane road and coming up to a light, and the person next to me just started getting closer and closer and closer, and darn near ran into the side of my car. Why? Well, I looked over and they were texting and driving.
That's
and
crazy.
So it really, it's amazing when you see the kind of change. You combine these things where there's so many more people on the road, and so many of them are paying less attention than they ever did before. And that means we stay busy as personal injury lawyers because there's an awful lot of car accidents.
Oh, there sure are. The amount of cars and amount of traffic has increased, but the roads really haven't improved in such a point where it's to overcome that growth. And that causes a whole bunch of crashes.
It's they're certainly trying to play catch up now, but I don't know that they can ever catch up when they're getting 1,000 residents a day moving to the state. So it's pretty amazing, and not having light rail to take pressure off the roadways. It's kind of a perfect storm, unfortunately, for people that are trying to commute around the Tampa Bay area. Things that used to take us maybe a half hour. We'd budget a half hour to 45 minutes to get from Clearwater to the Tampa courthouse. Not anymore.
No.
You better double that time.
That's exactly true. They're doing all kinds of construction. They're going to start construction on US 19 just north of Countryside Mall, and eventually that's going to be good. But in the meantime, that's just going to be. I mean, there's a reason why the bumper sticker says "Pray for me, I drive on US 19." Now it's just going to be worse during all that construction area and such.
Yeah.
So it's important. It's very important because of the traffic and the distractions, both self-induced and also just on the roads. It's so important to check your automobile insurance coverage, because as Brian knows, and if the faithful listeners of our show also know, but in Florida, you're not required to carry bodily injury liability coverage. That means if you get hit by somebody who isn't carrying bodily injury liability coverage, you have no means to recover your unpaid medical bills, your lost wages and such, unless you were proactive and you got a certain type of insurance coverage. And Brian, why don't you tell our listeners what type of coverage is what I think is the most important car insurance coverage you should have?
I think we're going to agree on this 100%, Matt. I mean, really, for anyone who's stopped at a stoplight right now, look behind you. And you're probably under the impression that person has coverage that would pay for your injuries, because you've probably heard that there's some kind of minimum requirement in Florida. Well, the truth of the matter is there's no requirement for that driver behind you to have bodily injury liability coverage. So what Matt's alluding to is you have to be proactive and protect yourself and your family. And the way you do that is you buy an optional coverage. Remember, this is an optional coverage. It is not a mandatory coverage, and that's the key. This coverage is known as uninsured motorist coverage, kind of quickly known as It covers you when the other driver is completely uninsured or when they're underinsured. That is, they don't have enough money to pay for the injuries that they've caused to you and everyone in your car when they run into you. And if you don't have this coverage, you've committed the biggest insurance mistake that you can commit. So if you remember nothing else from this show, the important thing is check your policy for uninsured motorist coverage. It's actually sold two ways, stackable and non-stackable, but I don't want to bog this down too much. I just want you to get stackable coverage.
That's so important.
Well, I actually have two questions based off of that. First things first, do all insurance companies offer that type of coverage, like Geico, Progressive, or is it just, as far as you guys know, select insurance companies that offer that?
No, under the state of Florida, all policies, all insurance companies that write car insurance policies are required to offer the uninsured motorist coverage.
And second of all, I've seen a lot of this start popping up on social media more and more lately. The idea of getting involved with having dasher cams in the car for purposes of like if you have to go to court or for insurance claims or whatever. I want to take from both of you on this. What's your feeling on having dasher cams for like the front and the back of the car? Is it worth the investment? Is it something, at least from a legal perspective, it's worth getting?
Yeah, it's a very good question, Matt. Brian, what do you think about those cameras?
I think it's an excellent question. And quite frankly, with the way technology has advanced, I mean, you can just look in your own personal automobile. When you put it in reverse now, you've got a backup camera on almost every vehicle that's out there. And so to me, it's a great idea to have because inevitably, many times we are indeed, even in rear end collisions, I've been involved in cases where the person makes a claim that you, as the person that was sitting at a stop, they'll swear under oath that you weren't at a stop, that you came to a sudden and unexpected stop, and that you caused the accident when they rear-ended you. And the easiest way to deal with that when there's no witnesses and it's a he said, she said case is to have those cameras. Quite frankly, I'm surprised that technology hasn't installed those in automobiles really automatically so that information is there. But
the insurance companies don't want it, though. I don't think.
I mean, I know a lot of cars have backup cameras like mine does. Mine's a 2018 Toyota. And I have the backup camera, and it'll beep at me if, like, I'm looking one way, but I don't see something coming from the other side. My backup camera will actually beep at me saying, hey, there's something coming, stop.
Right.
So that should be, I think, mandatory on all cars from now on, having the alerts for backup cameras. And I agree, dash cams, both front and back, should be required by all cars.
Right. I had a case just a few months ago where my client was stopped. The client behind her was stopped. And a box truck, it was on Drew Street right here, a box truck was just apparently not paying attention and just slammed right into the back of the middle vehicle, propelling it into our client's vehicle. And of course, the box truck said, oh, those two came to a sudden and unexpected stop, just like you were talking about, Brian. And that video popped up. And we shared it with the insurance company, and it showed that we were at clear stop for many seconds. The car behind us was at a clear stop for many seconds before this truck just slammed into it. And so, to say the least, the insurance company finally agreed to pay for the property damage and take responsibility. But that's another case right there. That box truck, it's a company box truck. Now it was a small company. But they had $10,000 worth of bodily injury liability coverage, and it was a 10-20 policy, meaning $10,000 per person, $20,000 per accident. And we had one person injured, and the other person in the middle car had two people injured. And so, yes, they had liability coverage,
but not much.
Not enough. And that's why that UM or underinsured motorist comes into play so importantly. Yeah, and there was a time when UM first came out that the insurance agents wouldn't be promoting that. Wasn't that right?
Yeah, and I really think it's still that way. Unfortunately, a lot of times when you talk to your agent, I mean, I know I even had it happen to me personally when I was purchasing an umbrella. They sent it over to me and highlighted where they wanted me to sign, and they wanted me to sign away the uninsured motorist coverage for my, liability umbrella policy. So, yeah, I mean, unfortunately, what we found is that big insurance companies, they want to sell you bodily injury liability coverage only after they check your record and find that you are a great driver, a responsible person, and unlikely to cause an accident as a result of your negligence. Then they're happy to sell you that bodily injury policy. The problem is they don't want to sell you uninsured or motorist coverage because when they do, they're protecting you against every bad driver out there whose record they can't check.
That's right.
So it actually is exposure for them. So they, from what I've seen, they prefer not to sell it to you, which, and they have ways to try to discourage you from taking it.
Well, it's worse now because now a lot of insurance policies are issued online, and so it's the sign now type of thing to just click here. Don't bother reading. We'll send you right down to where you're supposed to sign it, and then they click it automatically and electronically, and they don't really know that they're rejecting the uninsured motorist coverage.
Yeah, I mean, there's no bigger insurance mistake that you can make, because uninsured motorist coverage clings to you and your family members. And by that, I mean, when you get into someone else's car, if you've purchased uninsured motorist coverage, you have that coverage in the event you're involved in an accident in someone else's vehicle. Let's say that you decide that you're going to go on a walking trail or a biking trail, or just you're walking along the side of the road on a vacation or crossing a street. Like I say, the uninsured motorist coverage clings to you. And if you're hit as a pedestrian, as a bicyclist, you have that uninsured motorist coverage. We cannot stress enough, if you don't have uninsured motorist coverage, then you need to add it immediately. If you have any questions, you can get in touch with me or Matt at our office. Email, fax us over your declaration sheet, which is kind of the bill sheet that you get every 6 months. It'll outline what coverage is. If you don't have uninsured motorist coverage, you need to run to the telephone and call your agent and tell them to add uninsured motorist coverage immediately.
That's right. And if you have any questions in the next hour, give us a call here at 727-441-3000. And it sounds like we do have a caller on the phone.
We do. It's Lucy from Clearwater.
Lucy, thank you for listening. Thank you for holding, too. We appreciate it. How can we help you today?
Hi, this is Lucy Oliver, and I'm at home all day, and I'm watching all the TV shows and, commercials, and with so many commercials on TV, what's the best way to pick an attorney after a car accident?
That's a good question. I was homesick one day, and I got stuck watching TV during the day. Oh, my goodness. I was so tired of seeing personal injury attorneys commercials. But Brian, what advice do you have for Lucy? What's the best way? Is a TV commercial the best way to know how good an attorney is?
Yeah, Lucy, unfortunately, picking it by a TV commercial is usually the worst way to find your lawyer. But, the advertisements can, in fact, give you some good information about that firm. So what you want to look for is, first of all, does that firm practice only in the area of personal injury law? How long has that firm been around? What is their track record, so to speak? See what type of cases they've handled in the past and what type of results they have. See whether or not that firm has within it board certified civil trial lawyers, which really is the highest distinction for trial lawyers. Less than 2% of all Florida lawyers have achieved board certification. And, really to just pick it off of a commercial where someone tells you how aggressive they are,
or their size.
That's not the way to pick it. Unfortunately, you've got to do a little bit of homework, and you're right in that there's not really a clear path or clear information on what constitutes a good lawyer. But I would suggest to you that you should look at the things that I outlined. And
I would add just a few things. I think they should also go to the Google reviews and read the reviews, and also read what the attorneys respond to the reviews as well. I think that's important too, because it's really the unbiased opinion of people that have reviewed that firm.
Yeah, they've been there and done that. So they've actually sharing the experiences that they've had with the firm. So that's another certainly useful piece of information. And then, of course, families, friends, and coworkers are always a good thing.
Better.
And you kind of get all that information together and you can cross-reference, and that can help you make a good choice.
Was that helpful, Lucy?
It absolutely was. I'm going to be keeping that in mind.
Thank you very much. Thank you for listening. We appreciate it.
Thank you for taking my call.
Sure. That does free up a line. So if you have a question, it's 727-441-3000. Brian Caulfield's here and Matt Noyes, myself are here. We are two partners at the law firm of Perronick, Caulfield, Averill, and Noyes, the longest established personal injury law firm in Tampa Bay. We've been doing this since 1955. We are a voice of the injured. Unfortunately, in the law, sometimes the injured loses their voice. The insurance company doesn't want to hear what the injured person has to say, and so we proudly are the voice of the injured when someone gets hurt and they need representation. Brian, we talked with Lucy about ways to find a personal injury law firm. What makes Perronick, Caulfield, Averill, and Noyes different than any other personal injury law firm?
Well, I think you can tell a lot about a firm from its staying power. In other words, how long has that firm been around? Our firm, as you know, has been around since 1955. Obviously, we have developed a very strong track record of winning cases. When you've been around for that period of time, chances are, they call it the practice of law.
Right.
And so we've had, that many years of practicing law, and it gives us a great deal of institutional knowledge about the insurance companies, about the adjusters, about the defense attorneys that we're dealing with, even about, the courts and the judges that we're dealing with. So,
and they get to know us too.
Yeah, and
they know. I mean, insurance companies know which attorneys are gonna fold their tents and which are gonna march all the way to a jury trial.
Yeah, there's no question. The insurance companies. I know one time I was trying a case in Clearwater, and the defense lawyer told me that during the trial, part of what this big insurance carrier wanted was they wanted an assessment of the plaintiff's lawyer, so that they could kind of keep that in their records to know that if they ever see that person again, depending on the result, they will pay accordingly.
Right.
So,
and you and I have tried cases together, and I've watched you try cases by yourself, and I'm sure what they have as your assessment is a bulldog that knows every area of the law and will fight for their client like you wouldn't believe, because I've seen that as you try cases all the time. So.
Yeah, it really is important, because ultimately, it's what respect does the insurance company have for your claim is in part dependent upon what respect they have for your lawyer.
Right.
Will that lawyer take them all the way? And those are the lawyers that ultimately get the best resolutions for their client. Right.
And we kind of have a philosophy at the office that our clients, we don't have files. We have clients, and too many law firms have files. They see them as a pile of medical records, pile of lost wages and such like that, and just an insurance claim. And I mean, that's what the insurance companies do. It's our job to again be that voice to say how this accident has impacted this person since the crash, and more importantly, into the future.
Yeah, I mean, your client is your friend. And ultimately, if your job is to advocate on behalf of the client, it's incumbent upon you to get to know that not only that person's case, but get to know that person. Only then can you really understand the way the damages have affected them. And only then can you really be persuasive in trying to convey that to another person. I remember one heavily fought case I had that actually went to a trial. And I remember the defense lawyer saying to me, Brian, I'm worried about you. You take things so personally. And frankly, I looked at it as a compliment.
Yeah, I was going to say, that's a compliment from somebody.
Yeah, I mean, you have to care about what you're doing in order to do it well. And you got to put everything into it. And as you well know, Matt, when these cases go to trial, it is a knockdown, drag out. So, you need to be prepared to kind of bring, every weapon at your disposal to try to achieve justice for your client.
No, that's 100% correct. Well, we're going to take our break right now. While on break, if a question pops up, please feel free to give us a call at 727-441-3000. He's Brian Caulfield. I'm Matt Noyce, and we'll be back in just a minute.
This is the TAN Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the TAN Talk Radio Network.
Thank you for sticking with us. This is attorney Matthew Noyce, and I am here with my partner, Brian Caulfield, and we are two attorneys at the law firm of Pernick, Caulfield, Averill, and Noyes who feel it's important to dedicate our time to help educate the listeners of Tampa Bay. And that's why we do this show, FLA Law, on the radio. We do it every Tuesday from 5 until 6. Every Tuesday. I think next week, Jacqueline Bryant, another attorney is at our firm, another partner at our firm, is going to be hosting the show next week. But before the break, we were talking about what made us different and how it was, that we are personal injury attorneys, and that's what we do. We don't do criminal defense, estate planning, and personal injury. We do personal injury cases. And no other time than just recently is how important that is because very recently a lot of laws were passed that impact personal injury cases. And those attorneys who don't really follow the law or stay on top of the law can really wreak havoc to their cases. But Brian, why don't you tell our listeners just a little bit about, I think one of the laws that changes the statute of limitations. So if you can tell our listeners what a statute of limitations is and what it was and what it is now too.
Yeah, sure. The statute of limitations is a state law that provides you a certain specified period of time to sue the at-fault party. And there's different statutes of limitations for different types of causes of action, as well as who the defendant is in the case. But mainly the one we're talking about is in Florida, we had a 4-year statute of limitations. So if you think of a car accident where you got rear-ended, you had up to 4 years to file the lawsuit against the at-fault owner and driver. And that has been significantly changed. It's been cut in half. You now only have 2 years to do that under the new law. And that's just one of the very bad law changes, because I can tell you that many times we have cases where people treat and it takes them over 2 years to get done with multiple surgeries and therapy, but we still had the opportunity to resolve that case without having to have court system intervention. In other words, since we didn't have to file the lawsuit and we had the case set up, we could still have the ability to negotiate with the insurance company outside of bringing a courtroom case, and we would get the case resolved. Well, now we're going to be in a situation where even though the case isn't ready to be settled and the client may still be treating, we're going to be forced to file a lawsuit, clog what already is a clogged court system.
The system's already clogged up.
With what we had happen with COVID. And, really, no one can really understand what was the purpose of this law, and did anyone ever consider what the negatives are? So that's just one major change. It sliced in half the amount of time you have to file the lawsuit. And, there's a whole host of other incredibly awful changes. But, unfortunately, it happened very quiet, very late in the legislative session. And there wasn't just, no one thinks it's going to affect them.
No
one really understands how it's going to affect them, but they're going to have major effects. And one of the things as a Florida citizen that you enjoyed for over 100 years here in Florida is if your insurance company denied a claim, let's say, for example, you had, water damage, or you had, a tree branch fall across and cave in part of your house. And you had an insurance company that kind of lowballed you and didn't want to pay the full amount of the damages, or indeed said there's no coverage. You had a situation where you had a law in place to protect citizens from insurance companies wrongfully denying their claim. And the way they did that is they said that if you beat your insurance company, you're entitled not only for the insurance company to pay the claim, but they also have to pay your lawyer a fee. And so that allowed people to go out and get a lawyer that would judge the strength of the case. And if they thought the case was, meritorious, they could agree to take the case on a contingency fee basis where they only got paid if they won.
Like the David and Goliath story,
Now you're really pretty much at the mercy of your insurance carrier, because that law has been wiped away in one fell swoop. And now you're in a situation where, what are you going to do if you have a difference of opinion with your insurance carrier over the value of a loss? And let's say that the insurance company offers you $10,000, but you want $30,000 for the damage to your house. So you're fighting about $20,000. How are you going to hire a lawyer to go out and fight that?
Right.
You probably spend more money on the fight than you will on the total value of your claim. And so that people don't know it, but they have absolutely, their rights have been destroyed there as it relates to that.
No, and that's right. I mean, that's a $20,000 gap. But what if it's a $5,000 gap? The insurance company knows that, heck, why should we pay the full value? Let's just pay less, but just less enough so they can't get an attorney to help them. And if we do that on thousands and thousands and thousands of cases, look how much money we're going to get.
You're going to have to, go deal with paying a lawyer by the hour. And like you said, many small and medium cases, it just won't be financially viable for you to pay your own attorney, because when you do finally win, the amount that you had to pay to fight can kind of eat up the value of the claim. So that was just, it's difficult to rank how bad the changes are, but that's certainly, that one certainly, goes right up top.
And then there's another change in the law had to do with comparative negligence.
Yeah, here in Florida, that's a really important one. And where it's most important is kind of your typical trip and fall or slip and fall type case. Under the old law, since the mid-1970s, we were what's known as a pure comparative negligence state, where a jury would have the opportunity to look at the fault of both the plaintiff who was bringing the injury lawsuit and the defendant who the case was brought against, and they would take a 100% pie of fault, and they would have to divide that. So say, for example, you tripped and fell in a store, and the store said, well, it was dark liquid they fell on a white floor, and they should have been more careful and they should have noticed it. So they would argue to a jury that you were comparatively negligent. The jury would then assess how much fault you had versus, let's say, how much fault the grocery store had. And so let me just give you an example of what that means. Pure comparative negligence, if a jury found in favor of the injured person and awarded $100,000, but did find the person comparatively negligent and said that the person who fell, the jury felt they should have been more careful, and said they were 55% at fault and the grocery store was 45% at fault. Well, under old Florida law, your recovery would be reduced by your percentage of comparative fault. So when you got the $100,000 award, if you were 55% comparatively negligent, the court would take away 55% of your award, but you'd still get $45,000
because the premise owner was responsible.
Yes,
A
partly.
jury of their peers said that they were responsible 45%.
Right. And they were only required to pay their percentage of fault.
Nothing more, but nothing
right.
less.
But now, under the new law, if the injured person is found more than 50% at fault, they get nothing. And so the example I just gave you where, it was 55% at fault, in the old days, you'd have that $100,000 recovery reduced by your 55% at fault, and you'd get $45,000 from the defendant plus your costs. Under the new law, you get nothing if you're found more than 50% at fault. So the defendant, even though they've been adjudged to be negligent, and even though they've been found at fault, up to 49%, they now are responsible to pay nothing. And, interestingly about that, as we let the dust settle, you can even read commentary from big insurance defense firms that defend insurance carriers who are usually defending cases, whether it's grocery stores, department stores, places of business. Even they are heralding this law and saying, hey, we no longer have to pay in accordance with our percentage of fault if we can just get a jury to find the plaintiff more than 50% at fault, and that it will lower the value of all premises liability cases, because they will have that threat available to them of they don't have to win the case. They just have to convince a jury that the plaintiff themselves was more than 50% at fault. And so that is another monstrous change to the law.
It's just unfair. I mean, it's just totally unfair for the little guy. It's great for big business. It's great for insurance company, but it's just not fair for the little guy.
Yeah, it gets worse. I mean, they made some major changes to how you can be awarded your medical expenses, past and future. And this one's even more puzzling. For many years, you would present your medical bills and a jury would decide if they're reasonable and necessary and related, and they could award them. But now what they want to do is they want to allow into evidence whether or not you have health insurance. And if that breaks a longstanding rule known as the collateral source rule, where they weren't allowed to put into evidence that you had insurance coverage because you had to pay back the insurance company. Typically, if your insurance carrier, health carrier, made any payments for your injury case. Well, now they have basically put like caps on the damages that you can recover. And those damages are whatever your insurance company paid. And even in the future, what your insurance carrier would pay for future medical expenses, even though your insurance contract only runs for 1 year. So the other bad thing about that is if you have no insurance, there's a limitation, like 120% of Medicare is all that you can recover from the at-fault party. But there's nothing in the law that says the big level 1 trauma center that you ended up in has to take 120% of Medicare.
I mean, if you have a severe car accident, and because you had to file the lawsuit within 2 years, and so you had to go through that litigation process, and you don't have health insurance, and you're not eligible for Medicare, if you present that case to a jury and you have to talk about the future cost for the surgery that is certain to occur, the limit that you can tell the limit, or I guess there's evidence that can be presented, is 120% of Medicare, even though the guy is not eligible for Medicare.
Right. And even though the hospital, let's say you're hit by a drunk driver and you get this huge bill because you're in the hospital in a coma for a week and you're in the hospital a month, you come out, you have this really large bill. You don't have any health insurance. And then when it comes time to sue the at-fault party says, excuse me, I'm not paying the full bill.
Right.
I only have to pay 120% of what Medicare would pay. I mean, it's just,
and then
some
the
of these
provider
things were
says,
just,
okay, now injured person, pay the difference.
rest. There is no corresponding law that says the hospital or the healthcare provider has to take what these. So this was really kind of rammed through very quickly, and it'll be very interesting. There'll be years of litigation now regarding whether these law changes are constitutional, and the law was so poorly drafted. There's going to be
fighting right now.
Years of fighting about. Look, there's already been a fight about whether it applies retroactively or not. Even that is generating all kinds of litigation. So it's really been if you're an injured person, it's a very negative change. There's really, it's just simple to say that your rights got trampled on.
Right. And if you have any questions regarding the new law, give us a call at 727-441-3000. It does look like we do have a caller on the line.
We do. Lauren from St. Pete wants to get in on this discussion.
Lauren, thank you for listening and thank you for holding. How can we help you?
Hi. So my sister and I were actually having a debate last week. She had an accident and she doesn't want to call an attorney. And I was trying to convince her that she really needed to get a consultation. But why is it, is it better to try to deal with the accident on your own? Or can you deal with the insurance company directly? Why do you really need an attorney after an accident?
That's a good question. I'm going to give a typical lawyer answer, and then I'm going to let Brian Caulfield answer the question as well. My typical lawyer question is it depends. It depends on a lot of situations after the crash. It depends if you're hurt. It depends if there's a dispute of negligence. But I always give the analogy when I talk to my clients. I said, well, if my AC breaks at home, I can try to fix it myself. I can try to do it, but wouldn't it be better to call an expert who knows the routine and knows what needs to be done to make sure it doesn't break the next time? Same thing with handling an auto accident claim. You could try to do it yourself, but the insurance companies have lawyers looking out for themselves, and I just think it's right that an injured person at least get a consultation with an attorney who understands it as well. Brian, what do you think?
Well, Lauren, the best advice you could give to your sister is to tell her absolutely to go get a consultation. I mean, we talked earlier about how many TV ads there are. Almost every lawyer ad you'll see, there's a free consultation.
And we do free consultations.
Yeah, we do them as well. I mean,
okay.
you first of all, she has to remember who she's up against, okay? She is going to be negotiating with someone who is the enemy. They have a built-in incentive to pay her less than her case is worth. There have been objective studies done that show, even the insurance company's own data shows that people who are represented get more money for their injury case. And, she's essentially dealing with insurance professionals and, she's becoming a lawyer, So one of the things that my old partner used to say when people would say, do you have to get a lawyer? The answer certainly is you don't have to do anything. But if you care about the result, if the result really matters to you, you should avail yourself of having an expert on your side. Go get the consultation, have it explained to her what her rights are, and then and only then she can make a decision about whether or not she needs to retain an attorney. But to try to go this alone up against professionals that as much as they try to talk nicely to you, they don't have your best interests at heart. I've had plenty of cases where insurance adjusters have been allowed to go right out to a person's hospital room with a release document trying to get them to sign. I've had cases in which people have signed. They've signed away their rights for $3,000, and they said, well, wait a minute, the adjuster said that I could reopen the case if, it turned out my injury got bad. And then when the injury did get bad, Then they came to me. Now, fortunately, I had enough proof in that case, and the insurance company changed their mind and decided not to stand on the release. But it's a bad idea to take on an insurance company and try to do things on your own. And that the more serious your injury, the worse it is to make the decision to try to handle it on your own.
And you kind of talked about it, Brian. What happens is you have one bite at the apple. Once the release is signed, it's for not just the damages that occurred up to that date. It's forever and ever and ever. It's all your future medical bills. It's all any possible surgery, any lost wages and such. So it's so hard to predict, to know what your damages are if you don't do this on a day-to-day basis. So, Lauren, was that helpful?
Absolutely.
Right.
I will. I'll give her your contact information and have her give you guys a call.
Perfect, Brian. Why don't you tell all our listeners how they can contact us when it's not 5 to 6 on Tuesday?
Sure. Our office phone number 727-796-8282. Our website is usalaw.com, and we also have another website, voiceoftheinjured.com. Always good ways to contact us, and then you can actually email us through the website as well. So we try to be accessible to folks 24 hours a day, 7 days a week. And for folks like Lauren who, are dealing with a family member or loved one, it's excellent advice to try to get them to an attorney before they make a lifetime decision of resolving their case that they could regret later.
Yeah, and we have offices. Our main office is in Clearwater, but we have a office in St. Petersburg as well, and we meet clients in just about any place. We meet clients in Newport Richey and Tampa, Spring Hill. We even met clients up in Spring Hill. We are there to help. We're there to educate. That's kind of what the meaning of this show is for as well. This is to help educate our listeners prior to a crash, but after a crash happens or after an injury occurs or malpractice occurs, part of our role is to be the teacher, to be the educator, to guide them through the maze that we go through on a daily basis that hopefully they never have to go through.
Yeah, there's plenty of times where we say, boy, if we just could have talked to this client before the accident and explained to them how important uninsured motorist coverage is, then they wouldn't be coming into our office where they bought $250,000 in coverage to pay for injuries that they caused to someone else, but they bought nothing for themselves, for their family members, or for anyone in their vehicle. They just unfortunately didn't understand what they were doing, and they rejected uninsured motorist coverage and committed the biggest auto insurance mistake in history.
Right, because as Brian was saying, the agents can charge your premium based on your driving record. And if you're a good driver, well, you can get lots of coverage for lots of bodily injury liability coverage for a fair price because they believe you're not going to cause any crashes. But what you're doing is you're spending all that money to protect everybody else from driving, from your driving, and you're doing absolutely nothing to protect yourself and your family from everybody else's bad driving. And we've seen it. There's hundreds of crashes in Tampa Bay every day.
Well, and even more important than that is typically the most irresponsible people in the way they drive are the most irresponsible people in the way they insure themselves.
That's true.
And so that means that the most serious cases that we get are usually ones in which there is little or no insurance to back up the person who was negligent. So you have people out there that have either no insurance or $10,000 in coverage, driving like maniacs, driving drunk, causing severe injury or death to our clients. And unfortunately, many times the only source of recovery is that uninsured motorist coverage on your own policy because it stands in the shoes of the at-fault party. I just can't emphasize enough that if you don't have on your policy, you're going to regret it one day because it covers you, like I said, not just when the other driver is uninsured, But when they're underinsured, so let's say you have a very big injury and the other driver has 100,000 in coverage, you think, well, that's not bad. But what if you have 300,000 in medical bills? If you had the additional underinsured motorist coverage, you take the at-fault party's $100,000 policy, and then you turn back to your own policy to get the remainder of your damages up to the amount of coverage you've purchased.
Yeah, I think that's so important. Lately, I've been seeing so many fleeing the scene of an accident. They crash, they cause a crash, they gesture to pull over, and then the person who causes the crash just flees the scene. And that's where uninsured motorists would come into play as well.
They call them phantom vehicle is the term we like to say, the phantom vehicle, the person that hits and runs. And so that does happen as well. So again, uninsured motorist, if you don't have it, you're essentially naked insurance-wise.
And what's good, some of my clients say, well, gosh, I don't want my insurance company to pay. I want the guy who caused the crash to pay. And really, that's what uninsured motorist does, because if the uninsured motorist carrier pays, what do?
They get to go after, they have to deal with the hassle of chasing after the uninsured motorist to try to get their money back. And you don't have to worry about that. That's their job, and they're much better suited to do it. And quite frankly, many times the uninsured motorist doesn't have any money to pay the insurance company back. So, the important thing is to think about where you want to be if you or a family member that you get this horrible news that someone you love or in your family has been involved in a severe accident. I can almost assure you that the person that caused that severe damage is going to have not enough coverage to pay for all the injury they've caused. And so, if you don't have that uninsured or underinsured motorist coverage to back up the coverage that they bought, then you're committing the biggest insurance mistake. Hopefully you'll never need it and you'll never have to access it. The good news is it's much cheaper to buy than the liability coverage that you're buying to protect other people. And so I just can't emphasize enough. Unfortunately, the law has done some very bad things to try to kind of dissuade you. In the good old days, I'm old enough to remember when you bought bodily injury liability coverage to protect other people, you had to be sold uninsured motorist coverage in the exact same amount.
Right.
And so that was great. But under the new law, you can simply choose to reject it, or you can choose to buy less than you bought to protect other people and just sign a form that I have every client swear to me that they never signed.
That's
when
right.
I ask them if they have
And
UM.
with the electronic signature, they have problems too, and you can't prove that. Well, you have about 2 minutes left, Brian. So why don't you again tell our listeners how they can reach out? You've been practicing personal injury and malpractice and all our areas of law, gosh, for 35 years. Is that right?
Yeah, I am in. I'll be in year 35 in September.
And I have 32, so we're not too far behind. And so, why don't you tell our listeners how they can reach out to us, not just for representation, but also for guidance should something happen?
Yeah, I mean, the great way to get in touch with us, just pick up the phone and give us a call, 727-796-8282. We're happy to take any questions that you have on your insurance policy, because we'd much rather before than after.
Yeah, and we encourage you to listen next week to Jacqueline Bryant as she gives more information on FLA Law on the radio. But in the meantime, drive safely and watch out for those who don't. I'm Matthew Noyce, and that's Brian Caulfield. Thank you for listening.